Good afternoon. Thank you very much for taking time out of your busy schedules to participate in today's webinar. I am Aaron Simpson. I'm one of the partners in Hunton's privacy and cybersecurity practice, resident in our New York and London offices. And as the title indicates, our focus today will be squarely on the significant policy developments of the past week or so emanating from Europe in the context of cross-border data transfers. As each of you can certainly attest, this is a hugely important issue for all global businesses. And we look forward to this opportunity to share with you our perspective and recommendations with respect to these important developments. To do that, we have assembled a group of participants for today's session from our global privacy and cybersecurity team that operates seamlessly across borders on data protection issues that impact our clients in the EU, the UK, and the US. In the specific context of cross-border data transfers, which is our focus here today, a truly global perspective is necessary to understand the full scope and impact of these EU policy developments. Joining me to do that here today are my partners and good friends, Bridget, Treacy, and David Dumont. Bridget is based in our firm's London office, where her practice is focused on all aspects of privacy, data protection, information governance, and e-commerce issues for multinational companies across a broad range of industry sectors. Bridget is a preeminent thought leader in the UK on data protection issues and is the editor of the specialist privacy journal, Privacy and Data Protection, as well as a contributor. Bridget has been widely recognized for her work on behalf of clients, including in both chambers, where she is ranked in band 1, and the Legal 500, where she is included as a leading individual. David Dumont is based in our firm's Brussels office, where his practice involves advising large multinational clients with issues arising under EU data protection law. Like Bridget, David is also a thought leader in Brussels and across the European Union on data protection issues, including the context of the cross-border data transfer issues we are discussing here today. Next slide, please. Just a little background on who we are more broadly. Beyond Bridget, David, and myself, the privacy and cybersecurity team at Hunton consists of nearly 50 privacy and cybersecurity professionals located in the US, the EU, the UK, and Asia. Most importantly, we are a seamless group of privacy professionals who work collaboratively across borders to provide our clients with cost-efficient and effective solutions to their data protection needs on a global scale. Given the nature of the regulatory issues in this space, if you have an employee or customer or website, you have a data protection issue. And accordingly, we represent clients across every industry sector, including the technology sector, financial services, retail, consumer products, advertising, healthcare, energy, transportation, and many others. In addition to our legal practice, and particularly relevant to the policy discussion we will be having today, the law firm also maintains the Center for Information Policy Leadership, which is the world's preeminent privacy think tank, and which is also deeply involved with its members on the cross-border data transfer issues we will be discussing today. Led by our colleague and dear friend, Boyana Bellamy, who was the 2019 recipient of the IAPP's Vanguard Award, the center works across the globe with industry leaders, regulatory authorities, and policymakers to develop solutions and best practices for privacy and the responsible use of data. Given the rich policy environment in which we all operate, the center is incredibly active and productive. This year alone, the center has held 56 events and published 32 papers. This includes 49 events that they have held virtually since March 1st. Needless to say, the pandemic is not slowing down Boyana and co, and I could not recommend their work more highly to you. Lastly, don't forget to check out our award-winning privacy blog, which is updated constantly to cover these and other significant global privacy developments. Next slide, please. Let's jump into today's agenda. Our goal for today is to provide you with our perspective and recommendations on the recent data transfer recommendations published by the European Data Protection Board, as well as the new set of standard contractual clauses published by the European Commission. To do that, we will first frame the issues for you, then we will dive into the EDPB recommendations and what they mean for organizations. Once we finish that, we will focus our attention on the new standard contractual clauses, talking through some of the positive developments, as well as some that may surprise. Lastly, we will talk through practical next steps for organizations to consider as they grapple with these vexing policy issues. Let's start by quickly framing the issues here. Please jump ahead to slide 5. It seems like it was ages ago, but it has only been about 4 months since the Court of Justice of the European Union's landmark decision in Schrems II was published in July. Since the decision was published, international businesses have been working steadfastly to implement the key aspects of the decision. As a refresher, that work has been multifaceted. It has included moving away from reliance on the Privacy Shield framework for more than 5,000 companies who had previously certified to the Shield. In addition, based on the court's ruling, companies have worked hard to develop transfer risk assessment tools to assess data transfers on a case-by-case basis when they are relying on the standard contractual clauses. In addition, based on the results of those assessments, many companies have been working with their affiliates and their business partners to supplement the standard contractual clauses with additional contractual safeguards where that is appropriate. In addition, companies have been focused on their own organizational safeguards, including with respect to building policies and procedures to help ensure compliance with the key aspects of the Schrems II decision. For many organizations, this has been a significant amount of work. During this period, businesses also have been eagerly awaiting guidance from the European Data Protection Board on the safeguards to employ in the context of global data transfers, as well as the European Commission's new set of standard contractual clauses. The standard contractual clauses have been long awaited, really since the effective date of the GDPR back in 2018. Next slide, please. Over the past week or so, we have received this long-awaited guidance from the EDPB and the proposed standard contractual clauses from the European Commission. The guidance from the EDPB came on the 11th of November and is focused on its recommendations regarding supplementary measures to consider in the context of cross-border data transfers. This guidance is open to public consultation until the 21st of December, which was the result of a much welcomed extension granted late last week from the original date of the 30th of November. Dovetailing with this guidance, the EDPB is also recently published recommendations on European essential guarantees. This guidance complements the recommendations on supplementary measures and provides criteria that are intended to help companies evaluate non-legal frameworks in keeping with the decision in Schrems II. Not to be outdone, on the 12th of November, the European Commission published its draft implementing decision on standard contractual clauses and released its proposed new set of clauses. This decision is open to public consultation until the 10th of December, after which the clauses are expected to be finalized. Taken together, this is a truly momentous set of developments in the European Union and beyond, given the scale of the activity they cover. When just talking about the EU, the UK, and North America, transatlantic data flows support upwards of $7 trillion of commerce. And that number ticks much further north when you expand beyond North America into commerce with the rest of the world. Beyond the business reality, both the EDPB recommendations and the new standard contractual clauses provide guidance with respect to important and particularly thorny issues raised by the court in Schrems II. Beyond just the Schrems II context, the European Commission's new standard contractual clauses are the first new set of clauses in the decade since the controller to processor clauses were published in 2010. Given the expanded scope and application of the GDPR, relying on the existing standard contractual clauses was, for some business models, kind of like screwing a square peg into a round hole, just not a perfect fit. The bottom line here is that the policy environment globally in the privacy and data protection arena is scorching hot. I think this is something that you probably all perceive in your own day-to-day work lives. We have emerging law in hugely important economies like Brazil and India. Just last week, my colleagues and I spoke to many of you about the material changes to California law resulting from the ballot initiative known as the California Privacy Rights Act that was passed on Election Day in the United States. And let's not forget about Brexit and the data protection implications there. Add to this mix these latest developments in the European Union, and it becomes clearer than ever that global businesses have quite a lot on their plate when it comes to managing privacy and data protection issues these days. To help make sense of it all, I will now turn it over to my partner and friend, Bridget Treacy. Thank you.
Thanks very much, Aaron, and hello, everyone. What I want to do now is to take a closer look at the recommendations and the European Essential Guarantees, and we'll begin first with the recommendations. I think it's worth just reminding ourselves here that the starting point for the European regulators is that the GDPR protects individuals' personal data, and this protection extends beyond Europe's borders to wherever the data happen to be processed. Responsibility for ensuring this protection travels along with the personal data lies with the exporter. And as we know, the protection can be achieved through a hierarchy of measures. Just very quickly, the first is transfer to an adequate country. Second, appropriate safeguards, or thirdly, exceptionally, by relying on a derogation. And we'll look at these in more detail in a bit. We also know that following the Schrems II case in July, the Court of Justice of the European Union noted that it might not be enough just to rely on one of these measures. Transfers need to be assessed on a case-by-case basis, and a risk assessment needs to be undertaken. The court also ruled that even where you use standard contractual clauses, they may not be enough on their own to ensure essential equivalence with European law, and so you may need additional safeguards. Before we start to look in any more detail at the recommendations, I just want to draw out a couple of general points that the EDPB made in their recommendations document. The first is that the recommendations offer a roadmap for undertaking this assessment of essential equivalence, and we will look at this in detail. But first, we should note that the board made the comment that the right to data protection has an active nature. So passive compliance is not sufficient. I think the approach that many companies have perhaps historically taken to assessing and documenting transfers in the round would now be regarded as a somewhat risky strategy. Much greater granularity is required, and the obligation to safeguard data transfers is a continuous process. It's not one that you can deal with in one go at the outset of your relationship with the importer when you simply sign up to a set of standard contractual clauses. Regulators' expectations have changed, and they expect greater granularity when addressing transfers, and this is an important takeaway from the recommendations document. The second point I want to note is the role of accountability. So the European Data Protection Board emphasizes the role of accountability in data transfers. In fact, they frame the recommendations as the application of the accountability principle. There are many references to accountability in the document itself and frequent reminders that controllers and processors have to be able to demonstrate their efforts, both to individuals and to data protection regulators, and also document their decision making. However, and this leads me through to my third point, which concerns the risk-based approach, there's an important component of accountability that incorporates a risk-based approach to complying with GDPR. And this is clearly referenced in Article 24.1 of the GDPR. It requires that account is taken of the nature, scope, context, and purposes of processing, as well as the risks of varying likelihood and severity for the rights of individuals, and that appropriate technical and organizational measures are then implemented. I think one of the most frequently heard criticisms of these recommendations is that in places they appear to lose sight of this risk-based approach, which really is integral to the GDPR. And I think if I could make one plea to the EDPB, it would be to highlight in the document the role of the risk-based approach. David will mention this in the context of the draft standard contractual clauses released by the European Commission. They do take the risk-based accountant approach, and I think it would be helpful to have some consistency on this point. Moving on to the essential guarantees, this document is probably best considered as a kind of compendium of European case law to help assess whether the surveillance measures of another country go beyond what is necessary and proportionate in a democratic society. So the guarantees are based on decisions of both the European Court of Human Rights and also the Court of Justice of the European Union. The European Data Protection Board regards the guarantees as being relevant to assessing interference by the surveillance measures in place in the non-European importing jurisdiction. So the guarantees are part of the overall assessment of whether a country provides essentially equivalent safeguards, but clearly they deal with just one aspect of the assessment. So far, they've been criticized by commentators as being too conservative, and one actually noted that most, if not all, of the European member states would probably not pass the test of the European essential guarantees. Right, let's now turn to the roadmap that the EDPB proposes. This, as I said, is framed as accountability in practice, and we're going to look at what each of these steps requires. The first step is to ensure that data exporters have a detailed understanding of their transfers. And as I've said, it's clear that the board expects significant detail here. They use the term mapping, and they suggest that exporters start by building on their Article 30 records of processing activities. They also remind exporters to consider data minimization. So the data that's transferred needs to be adequate, relevant, and limited to what is necessary in relation to the purposes for which it's transferred. This needs to be verified and documented as part of the accountability obligation. Moving on then to the second step, this involves identifying or verifying the transfer mechanism that you plan to use. And there are three basic choices here in a hierarchy, and we've already touched on them. So there's the adequacy decision, appropriate safeguards, or rarely derogations. Adequacy is where the European Commission has issued an adequacy finding under Article 45, and the data can flow from the EEA to that country without an additional transfer tool. But you have to monitor whether the adequacy decision is revoked or invalidated, and you might still be subject to complaints to a data protection regulator, who in turn could take the case to the national courts and seek a referral to the Court of Justice of the European Union, all of which occurred in the Schrems cases. The second level of the hierarchy is appropriate safeguards, and most transfers fit here. So where the transfers are regular and repetitive, the recommendations emphasize that the transfer tools in Article 46 of the GDPR should be used. These include not just the standard contractual clauses and binding corporate rules, but also contain provision for codes of conduct, certifications, and ad hoc clauses. And then there are the derogations. These are regarded as exceptional and should only be used for occasional and non-repetitive transfers. Now we move to step 3, and this is where things become challenging. When you rely on appropriate safeguards under Article 46, you have to assess whether the transfer tool is effective in practice, or whether the law and practice in the importing country impinges, and that's the term that's used, impinges on the effectiveness of the safeguards of the tool that you're relying on. How do you do this? Well, the European Data Protection Board considers that the assessment needs firstly to consider the context of your specific transfer. So the circumstances that they list that need to be taken into account are the purposes for which the data are transferred, the types of entities involved, the sector in which the transfer occurs, the categories of data, whether the data will be stored in the third country or whether there's merely remote access to data stored in Europe, the format of the data, so whether it's encrypted or pseudonymized, and then the possibility of onward transfers. Now, in addition to considering the particular circumstances of the transfer, you also need to consider applicable law, and this is the challenging part. You need to assess whether the applicable law impinges on the Article 46 commitments. So do these local laws of the importing jurisdiction impact the effectiveness of the safeguards and fundamental rights otherwise afforded to the European data subject? You should also consider specifically what are the requirements to disclose data to public authorities, and are these limited to what is necessary and proportionate in a democratic society? And in making this assessment, the relevant standard is the European Charter of Fundamental Rights. And the European Essential Guarantees come into part of this assessment as well. So when assessing applicable law, the guarantees document provides a list of criteria to exporters to help them assess whether the legal framework governing public authorities' access to personal data in the context of surveillance activities can be regarded as permitting a justifiable interference with the rights of European individuals to privacy and protection of their personal data. Now, the challenge in using the Essential Guarantees document is that it is pretty conservative. In addition to that, in some countries, not all of the relevant law or guidelines are going to be publicly available. Where the law is lacking, the board says you should look at other relevant and objective factors, such as reported precedents, legal powers, and available technical, financial, and human resources. This is likely to be overwhelming for most companies. They're not going to have easy access to the information or be able to assess its credibility. And I think in this particular context, of more significance is the fact that the board says you can't take into account subjective factors such as the likelihood of public authorities' access to your data when you undertake this assessment. And this seems directly at odds with accountability and the risk-based approach of the GDPR. So this is an area where we would all benefit from more practical clarification from the board as to what it intends. In addition to considering the surveillance issues specifically, elements of the third country's legal system also need to be assessed, in particular by reference to the factors listed in Article 45 of the GDPR. So, for example, does the importing country recognize the rule of law? Is it a Convention 108 signatory? Does it have a comprehensive data protection law? Now, if having undertaken this assessment, the transfer tools pass the test, you can proceed, but you need to keep the position under review. If the transfer tools don't pass the test, you need to stop the transfer or consider whether you can put in place effective supplementary measures. And you need to document this assessment for accountability purposes. So let's move on to step 4. And this, remember, you only need to do if the assessment in step 3 reveals that the third country's legislation impinges on the effectiveness of the transfer tool. So the supplementary measures are in addition to the safeguards provided by the Article 46 tool, and they will fall into one of 3 categories: technical measures, additional contractual measures, or organizational measures. Now we'll look at these categories, but there's one point I wanted to note first. Supplementary measures are referred to in various places in the GDPR and also in the Schrems judgment. And in both of those instances, they are described in the round as supplementary measures. Here, the European Data Protection Board says that not all of these measures are equal. Specifically, the board says that contractual and organizational measures alone will not generally overcome access issues where the public authority's rights interfere with the importer's obligations to ensure essential equivalence. So, in the board's view, in some situations, only technical measures might be sufficient, and in particular in the context of surveillance. Reflecting on this, it might certainly be the case that only technical measures can provide a cast iron guarantee, but this seems to be an area in which the risk-based approach could play a significant role, given that possibly in the vast majority of cases, the transferred data is unlikely to be accessed. Okay, so how do you decide which supplementary measures will be effective? You need to consider the format of the data, the nature of the data, the length and complexity of the data processing workflow, and also the possibility of onward transfers. And then having regard to these factors and the risks that you've identified in the previous step, step 3, you then need to identify appropriate supplementary measures. And if we move through to the next slide, I've summarized these on the slide, but they're set out in their own appendix, appendix 2 to the recommendations. So there we have the 3 categories, and I'm not going to go through all of them, but I do just want to make a couple of points about the technical measures, given that they've been afforded such prominence by the board. The first point to note is that the board has offered 5 examples where technical measures are effective, and they are represented by ticks on this slide, and 2 where the technical measures are not. And this aspect of the recommendations document has raised particular concern and criticism to date. The scenarios in which the technical safeguards will work are really very conservative. So the first example is where the data are fully encrypted and the importer doesn't require any access. So that is not a typical example of a circumstance in which data would be transferred abroad from Europe. It might be one example, but it's not it doesn't represent the majority of scenarios. One of the other examples refers to encrypted data merely transiting a jurisdiction, which really is not a transfer at all. So these 5 examples are quite limited and they really don't reflect the real world. I think of more concern, however, are the examples where the measures can't be applied. And these are probably 2 of the most common examples of cross-border data processing. So transfer to a cloud or to another processor who requires access to the data in the clear in order to undertake the services that they're contracted to provide. And the second example is remote access to data in a business context. So for example, using a global HR or marketing database, which is hosted in Europe. These examples have caused alarm. I think the board, if you read the document closely, it seems as though the board may be saying that in these circumstances, technical measures alone won't be sufficient, possibly leaving open the fact that additional contractual or organizational measures could solve the problem. But this is not really clear in the guidance. And I think this particular aspect really deserves to be clarified in the recommendations document. In addition, there are the contractual and organizational measures, which I'm not going to go through. Safe to say that the contractual measures will obviously be subject to negotiation between the exporter and the importer. And some of them actually are pretty tough. Okay, moving through then to the next stage of the assessment. So this is step 5. At this point, you then take any formal procedural steps that are required to implement your supplementary measures. So for example, if you use standard contractual clauses, any supplementary measures can't contradict the terms of the standard contractual clauses. And if they do, what you need to do is to get your clauses, your amended clauses, authorized as ad hoc clauses by your relevant supervisory authority. And then the final step is step 6, which is this ongoing obligation to reevaluate the level of protection that's provided and to monitor any developments that might affect it. So the recommendations really highlight that the principle of accountability requires continuous vigilance. So against that background then of this walk through the roadmap, I just wanted to pull out briefly some key challenges that arise from this document. The first is the role of the risk-based approach and the fact that it's not explicitly acknowledged. I've already given a couple of specific examples of that. I think specifically acknowledging the role of the risk-based approach really is a crucial part in making these recommendations workable, and it would be great to have some more clarification there. Obviously, and I was very conscious of this in explaining it, but the legal assessment is complex. We know that this is a difficult task. The Essential Guarantees document is helpful at one level, but it's pretty conservative guidance, and it doesn't address everything. It focuses on surveillance. So I think overall, it actually still remains quite unclear what is required of companies in order to undertake this legal assessment. There have been informal comments that companies are not expected to replicate the Article 45 assessment. I've also heard it suggested that perhaps the best approach is simply to assume that every non-adequate country fails the test and just skip step 3 and move straight through to step 4 and to identify supplementary measures. I think that approach is also flawed, actually, because the measures that you identify in step 4 are meant to address the specific shortcomings of the legal assessment. So the legal assessment is complex. Moving on to the next point, and this is one I haven't drawn out, but it is relevant to note that the board seems to envisage the importer playing a more significant role. So for example, the importer is to provide relevant sources and information relating to their jurisdiction and the laws that are applicable to the transfer. If you also look at the suggested additional contractual safeguards, you might be further alarmed if you're an importer. And joking aside, these additional clauses will be for commercial negotiation, but there are clearly implications for cost and risk and the underlying commercial value of the contract. And it's possible that organizations, the importing organizations, are simply going to find some of this too challenging. I think we run a risk, and I've moved on to the next point, that these guidelines and the existing sort of position that we have may result in an increase in localization in Europe. So data localization, whether by default or not. And there's also a possibility that we may just see a worsening of compliance. And then just the penultimate point there, I've already mentioned the apparent preference of the board for technical safeguards. It would be good if this was clarified. And finally, implications for Brexit. I can't possibly repeat what we said in our recent Brexit webinar, but it is available for you to listen to at your leisure. Do remember that at the end of this calendar year, transfers from Europe to the UK are likely to require the same sort of assessment as a transfer from Europe to the US or indeed to anywhere else. The caveat to that is that, well, the UK might still receive an adequacy determination from the European Commission, but I have to say that hopes of that being determined before the end of the year are fading.
Thanks, Bridget, for these thoughtful insights on the EDPB's recommendations. Let's now turn to the new standard contractual clauses for international data transfers. As Aaron already mentioned at the start of the webinar, the European Commission released a draft of new standard contractual clauses for international data transfers on November 12th, so the day after the EDPB released its draft recommendations that Bridget just discussed. These new standard contractual clauses have been long awaited, actually already since the GDPR became applicable in May 2018, because as Bridget already mentioned, the GDPR sets forth a general prohibition on transferring personal data to countries that have not been recognized by the European Commission as providing an adequate level of data protection unless appropriate safeguards have been put in place. And these appropriate safeguards can be provided by a number of instruments, but in practice, standard contractual clauses adopted by the European Commission are probably by far the most commonly used mechanism. Standard contractual clauses as a transfer mechanism already existed under the GDPR's predecessor, the EU Data Protection Directive. And in the pre-GDPR era, the European Commission has adopted 3 sets of standard contractual clauses, one for controller-to-controller transfers in 2001, another more business-friendly set of controller-to-controller clauses in 2004, and then one set of controller-to-processor standard contractual clauses, of which the most recent version dates back from 2010. So although it was explicitly recognized that organizations can continue to rely on these existing sets of standard contractual clauses until they are repealed, the existing standard contractual clauses were outdated as from the moment the GDPR became applicable, as they reflect the regime under the Data Protection Directive. Of course, the European Commission was fully aware of this issue and started working on new sets of standard contractual clauses after May 2018. But in the meantime, the Schrems 2 case, which has been mentioned multiple times during today's webinar, was, of course, pending at the Court of Justice of the European Union. And let's not forget that although it was the privacy shield that ultimately got invalidated, it were actually the standard contractual clauses that the Court of Justice was asked to look into. With this in mind, the European Commission awaited the Schrems 2 ruling to finalize and issue its new standard contractual clauses, and it took approximately 4 months to digest the court's decision and reflect the issues raised by the court in the new set of clauses. So to summarize the background, the new standard contractual clauses released by the European Commission on November 12 are, of course, primarily aimed at updating the current sets of clauses in light of the GDPR, but the European Commission also attempted to address the issues raised by the Court of Justice of the European Union in the Schrems 2 case and made the clauses Schrems proof. So, next slide, please. And before looking into the content of the clauses in a bit more detail, I want to make a couple of general comments with respect to the setup of the new standard contractual clauses. First, and probably most importantly, it is interesting to note that the European Commission has chosen a new and different approach to the standard contractual clauses. While up to now, as mentioned earlier, there were 3 independent standalone sets of clauses covering 2 data transfer scenarios, in particular controller-to-controller transfers and controller-to-processor transfers. The European Commission has, for the new standard contractual clauses, chosen a modular approach. So instead of releasing several new sets of standard contractual clauses, the European Commission now seeks to take into account the complexity of modern processing chains by combining a number of general clauses with modular clauses. And the modular clauses need to be selected and implemented by the parties depending on their respective roles with respect to the processing of the data that is being transferred under the clause. By taking this approach, it will now be possible to rely on the new standard contractual clauses for a wide variety and maybe the full spectrum of data transfer scenarios that exist, namely the traditional ones, controller-to-controller transfers and controller-to-processor transfers, but also processor-to-processor transfers and even processor-to-controller transfers. This is, of course, a significant step forward compared to the existing sets of clauses, which only covered 2 very traditional data transfer scenarios, both involving a data controller exporting data from the EEA. The need to accommodate more diverse data flows, in particular transfers that originate from a data processor in the EEA, already existed long before the GDPR saw the limelight, and therefore I think that this new modular approach is really an important step for many organizations that, as Aaron already mentioned, have been struggling with fitting their data transfer realities into the limited traditional data transfer scenarios for which there are standard contractual clauses now. In terms of substance, the general clauses address issues that are common to any data transfer scenario, such as the obligation of the data importer with respect to government access requests, redress mechanism that should be available to data subjects, indemnification language in the event of a breach of the standard contractual clauses, the supervisory powers of the data protection authorities in connection with data transfers, obligations of the parties in the event that a data importer is unable to comply with its obligations under the clauses, clauses related to termination, governing law, choice of forum and jurisdiction in the event of a dispute, and so on. The modular clauses, on the other hand, deal with requirements that are specific to the data transfer scenario at stake and the respective roles of the data importer and exporter under the GDPR. So the modular clauses address, for example, the data protection safeguards that must be respected by the parties, requirements around the appointment of sub-processors, which are relevant in the context of controller to processor and processor to processor transfers, provisions around respecting data subject rights and the parties' obligations in relation to handling data subject rights, and liability-related provisions. In addition to the general and modular clauses, I also quickly want to note that there are a number of annexes that parties will need to complete when relying on the standard contractual clauses. In total, there are 3 annexes that will need to be completed by the parties. In Annex 1, the respective parties need to be identified, and the parties need to provide a description of the data transfer. Annex 2 should be completed to actually include a description of the information security measures that will need to be implemented. And finally, Annex 3 should be used to list the sub-processors that are relied upon if this is applicable. A general comment with respect to the annexes is that we do see, in particular for Annex 2, with the information security requirement, that the expectations on the level of detail that should be provided by the parties in these annexes is rather high. So after these general remarks, I now want to spend a couple of minutes on some of the key elements and key takeaways that caught my attention when reviewing the draft standard contractual clauses. The first key takeaway that I want to mention is the flexibility and the broader scope of the new standard contractual clauses. And there are actually 2 elements to this point. First, the new standard contractual clauses provide more flexibility for organizations that are not established in the EEA. In particular, the governing law clause included in the new standard contractual clauses now allows parties to choose as governing law either the law of the member state where the exporter is located, or alternatively, and this is the important bit, the law of one of the EU member states, provided that that law allows for third-party beneficiary rights. The second option makes it possible for organizations that are not established in the EEA, but that are subject to the GDPR, including organizations that are not organizations that are not established in the EEA, to actually rely on the standard contractual clauses as a data transfer mechanism, and as such legitimize their international data flows, which, as Aaron already mentioned, was difficult to date. The second element related to flexibility that I want to mention is the fact that the new standard contractual clauses now also envisaged to accommodate more complex and constantly evolving data transfer scenarios. The European Commission, in my view, clearly improves the standard contractual clauses by taking into account this reality, by stepping away from the more traditional one-to-one, never-changing transfer scenarios for which the current sets of standard contractual clauses seem to have been designed. Now, the new set of standard contractual clauses is clearly designed to accommodate situations where there are multiple data exporters and or data importers, which frankly is rather the rule than the exception. And furthermore, the new standard contractual clauses contain an optional so-called docking clause, which enables new parties to accede during the lifetime of the agreement. Again, something that is, at least in my experience, happening very frequently. Moving to the second key element of the new standard contractual clauses that I want to touch upon today. And this is, of course, not a surprising element, but definitely worth mentioning because it's one of the main drivers behind the update of the standard contractual clauses, namely the fact that the clauses now reflect the new legal regime in the EU, the GDPR. You see this mainly in the modular clauses that I referred to earlier, which are now aligned with the data protection obligations and safeguards that must be respected by the parties, depending on their respective role as a controller or a processor under GDPR. This includes safeguards relating to transparency, purpose limitation, data minimization, storage limitation, erasure and return of the data, security, limitations around the posting of sensitive data, onward transfers, accountability obligations of the parties, requirements with respect to the appointment of sub-processors, and also the provisions around data subject rights and the parties' obligations in the event of a data subject rights request. Again, this is absolutely not surprising because, of course, it has a significant impact on data importers because as the GDPR strengthened the data protection framework in the EU, the obligations for the data importers under the new standard contractual clauses are, similarly more robust. So it's not surprising, but it does have a significant impact for data importers. Quickly moving to the next key takeaway mentioned on the slide here, namely data processing terms, which is somewhat related to the fact that the clauses now more generally are aligned with the legal framework under the GDPR. And with data processing terms, I refer to the fact that the modular clauses for situations involving a data processor are now in line with Article 28 of the GDPR. This means that similar to the situation for the controller to processor standard contractual clauses pre-GDPR, the new standard contractual clauses will, once adopted, not only be a mechanism to ensure compliance with Chapter 5 of the GDPR, it will also help organizations comply with their obligations under Article 28 of the GDPR, which sets forth the minimum data protection obligations that must be imposed on a data processor by means of a data processing agreement. This solves an important issue that organizations are currently facing in controller to processor data sharing scenarios where parties need to supplement the current sets of controller to processor standard contractual clauses to ensure that their agreement actually meets the requirements of Article 28. Another significant change compared to the current sets of standard contractual clauses is that the new standard contractual clauses include a more comprehensive framework around onward data transfers. So for onward data transfers to additional recipients in third countries under the new standard contractual clauses, there are more prescriptive requirements. They are generally only allowed if the recipient exceeds to the standard contractual clauses. Protection of the personal data transferred is ensured by other means, or data subjects provide informed and explicit consent. In addition, it is worth mentioning that the modular clauses for processor-to-processor transfers impose certain obligations on importers that may require a direct interaction between a sub-processor receiving data under the standard contractual clauses and the initial data controllers. For example, the data importer must inform and cooperate with the data exporter and the data controller when becoming aware of a data breach. These obligations may prove challenging in complex processing chains where there is generally no direct interaction between the controller and the sub-processor. Think about a large cloud provider with thousands of controller customers and many sub-processors. Let's move to the last key takeaway now, before having a quick look at the next steps in the adoption process for the new standard contractual clauses. So the final point I want to cover is actually tied to what Bridget's focused on during today's webinar, meaning the impact of Schrems 2 on transfer tools, including the new standard contractual clauses. As mentioned, the European Commission clearly awaited the decision in the Schrems 2 case before finalizing and issuing the new transfer clauses. Consequently, the new standard contractual clauses include provisions that are designed to address the Schrems 2 ruling, including an obligation to conduct and document a transfer risk assessment and to make this available to data protection authorities upon request. The new standard contractual clauses also impose extensive obligations for the data importer with respect to government access requests, including obligations, notification obligations in case they receive such requests, obligations to review the legality of such requests, and to ensure that only the minimum amount of information as required under the law is provided when responding to a request. Let's now quickly look at the next steps in the adoption process. Here we are. So as already mentioned, the new standard contractual clauses are in draft form for the moment, and they're subject to public consultation until December 10. The final draft of the standard contractual clauses incorporating the feedback from the public consultation is expected somewhere by the end of 2020. After that, the European Data Protection Board and the European Data Protection Supervisor will issue an opinion on the final draft, and standard contractual clauses will be reviewed by the representatives of the EU member states in accordance with the comitology procedure. And the final standard contractual clauses are then expected to be adopted somewhere in early 2021. Once the final standard contractual clauses are adopted, there will be a transition period of 1 year during which organizations may continue to rely on the existing sets of standard contractual clauses, provided that their contract remains unchanged, with the exception of the inclusion of necessary supplementary measures to ensure that the transfer of personal data is subject to appropriate safeguards. For new relationships or where the contract between the exporter and the importer is changed, the new standard contractual clauses will need to be incorporated. A last point I want to put on everyone's radar screen is how this timeline interrelates with the timeline for Brexit, something that Bridget already mentioned too. So on this point, taking into account the steps I've just discussed, it's pretty clear that the new standard contractual clause will likely not be adopted before the end of the Brexit transition period on the 31st of December 2020. If that is the case, the new standard contractual clause will not constitute retained EU law and will not automatically be available in the UK. That said, it is expected that the UK will promptly implement a similar or an alternative transfer mechanism. So with that, I will turn it back to you, Bridget, to take us through the next steps organizations should consider taking in practice.
That's great. Thanks very much, David. And this is just really a final point, and it addresses a question that everyone is asking. How on earth should we all prioritize what needs to be done given all of the uncertainty? And so this is kind of an amalgam of questions that we are very frequently asked. And I've put 4 blocks on the screen that address 4 of the key issues that organizations are grappling with. And of course, the approach that you take is going to depend on your particular circumstances. But I think as a starting point, most organizations are likely to benefit from just pausing and reviewing their data transfers. I've mentioned already that DPAs clearly expect organizations to have a detailed understanding of their data flows, including the cross-border flows, and this needs to be documented. And what we've seen is that while some organizations made a really concerted effort to document their flows in the lead up to GDPR implementation in 2018, sometimes those records haven't been maintained. And of course, businesses aren't static. So this could be a good place to start. Review your record of processing activities and take stock. The next point is the privacy shield. So as we know, companies that had previously relied on the shield for their transfers need to implement a replacement transfer mechanism. The Schrems II judgment invalidated the shield. So if that was your mechanism for transfer, you really need to focus on this. Most companies have turned to standard contractual clauses with additional safeguards as required by the Schrems judgment. Some have said maybe they should await the new European Commission clauses rather than, sign up to the old clauses and then have to update them. There's obviously a considerable amount of risk associated with that strategy if you're continuing to transfer the data without a valid transfer mechanism. Then the third bullet there is Brexit related. So if you transfer personal data from Europe to the UK or from the UK to the rest of the world, excluding Europe and adequate countries, then you need to make sure that you've got a transfer mechanism in place, which from the 1st of January correctly identifies the UK as a non-EEA importer or exporter. And plus you obviously need a mechanism to cover Europe to the UK. If you need to implement new clauses to achieve this, then you're going to have to use the existing standard contractual clauses because the new ones won't be available by then. Well, it's extremely unlikely. And nor is it clear, as I said earlier, that the UK will receive an adequacy decision by then, although it's a possibility still. And then the final point is this preparation to implement new standard contractual clauses. This is a task for everyone that uses standard contractual clauses. You need to start thinking about transition. And as David explained, it will be mandatory to transition across, but there will be a 12-month window within which to achieve this. So while the order in which you address these various considerations will obviously depend on your particular circumstances. I hope that these remarks just give you some ideas for planning your next steps. And of course, we're here to help you and we'd be glad to discuss this further with you. Now, let me hand back to Aaron.
Thank you very much, Bridget. And thanks to everyone for participating. We have received a number of questions and we will not have enough time to go through them on this call, although we will strive to reach out to each of you who have asked questions. I might try in our last couple of minutes to go through at least one of them. One of the questions we received says that we are a U.S. company. Why, if at all, should we remain in the privacy shield as the U.S. Department of Commerce recommends that we do remain? That's a very good question, right? And as Bridget has made very clear, if you're on the European side of this equation, which is the side of the equation that imposes the legal obligation with respect to the extraterritorial transfer of data, right, then the privacy shield quite clearly will no longer do the trick, right? But if you're on the US side of the equation, right, and you're relying on the privacy shield to import data, remember what the privacy shield signifies, right? It is a series of actionable public representation subject to Section 5 of the FTC Act, right, and subject to the FTC's unfair competition jurisprudence. And so if you have certified to the privacy shield as a historical matter, even though it will not solve your European data transfer conundrum, right, it is a series of actionable representations that you have made publicly, right? And so on the US side of the equation, you are held to those statements, right? And so if you've made those statements historically, you have to live up to them with respect to the data that you collected pursuant to those statements, meaning your privacy shield, privacy notice, and your other compliance infrastructure that you built. And so the U.S. Department of Commerce is recommending that companies who have been certified to the shield stay certified to the shield. And most importantly, even if you were to leave the privacy shield, you would still have those obligations with respect to data you collected historically under your privacy shield privacy notice, right? And so for most companies, the most sensible path forward here is to keep your privacy shield certification, knowing that it does not solve your European data transfer conundrum any longer, but it does help you on the US side of that equation. There's another question here about what does data in the clear mean, right? When we talk about data in the clear, what we're talking about is data that can be accessed or seen by the recipient or during transit, right? So data in the clear would be in juxtaposition to data that has been encrypted, right? It is not in the clear. And this is something that the standard contractual clauses in the EDPB guidance speak quite heavily about, as Bridget and David spoke to. Another question here is whether or not we can consider that the new version of standard contractual clauses address or meet the contractual measures that are expected as supplementary measures. I think we all wish the answer to that question was yes, and that we could just close the book on this webinar and we could all be happy that that was the answer. But I think the answer to that question is that it's more complicated. And we will be continuing this dialogue on this topic as we learn more. And so, at this point, given we've hit time, I commend to all of you our blog for important material developments in this cross-border data transfer context, and also keep an eye out for future invitations to additional events on this and other topics, because obviously this is a dialogue, and it's one that we're going to continue to be having with our clients, and we look forward to your participation. So with that, on behalf of Bridget and on behalf of David, I'd like to thank you for your participation today, and we look forward to seeing you again at a future event. Thank you.